Rise.
Thank you. Please be seated. This is the time set for argument in our civil number 14-15. Robert Neiswaner, perhaps? Okay. Robert Neiswaner versus DOC. Each side will have 20 minutes in which to argue its position. The appellant may reserve a portion of that time for rebuttal argument. Counsel need to keep track of that time for yourself. We have read the briefs and conference this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellant may proceed.
Good morning, Your Honors. My name is Donna McDaniel with the law firm of Bin and McDaniel, and here with my partner, Martin Bin, today. And we're representing the appellant, Robert Neiswaner. And as Your Honors have read the brief, you're aware that our appeal has two parts to it. One part is that the Personnel Board allowed the Department of Corrections to violate its own policy. The other part is the Arizona State Personnel Board allowed the Department of Corrections to violate the law, and that law was ARS 381101. Now, both of these claims, the bottom line of both of these claims on appeal is that it has to do with documents extending the time to impose discipline. So I'm going to talk to you first about those documents, what they mean, what they are, why they're important. At the time that this case occurred, at the time the allegations were made against my client, Mr. Neiswaner, Arizona Department of Corrections policy said that when there's an allegation of discipline or misconduct against an employee, there's a whole department order on that. It's Department Order 601. It sets out the procedure of how this happens, what the process is.
I have kind of a preliminary question.
Sure.
Let's say and it's just kind of why departmental policy is dispositive. Let's say the department just said we're going to resolve any kind of employee discipline within 2 days, but then they take 10 days. Are you suggesting that that's the understanding that there's some sort of employment agreement, that there was collective bargaining involved or something, or if the department just on their own says we're going to do this in 2 days, but they end up taking a week, how does that create a basis for relief?
It creates a basis because this Department Order 601 is, as defined by the department in its handbook, which, first of all, is not an employment contract, just to make that point clear. The handbook says these department orders tell the employees exactly what to expect when this discipline occurs. This is the way, as the Department of Corrections, that we do things. When you tell an employee this is the way that we do things, and we're talking about thousands of employees here, and you impose the structure of how discipline is going to be imposed, and then you deviate from that structure for certain employees, that becomes arbitrary and capricious. That's the issue, is that it's an arbitrary and capricious action for the department to set out these policies, to have these policies.
But if there's a policy, and presumably if someone could be fired immediately, if they're kept on at pay during a period of time in which the department's considering what to do, how would an employee be prejudiced by that policy or by that departure from policy? The
employee is prejudiced partially just, again, I think it's important that regardless of what the policy is, if the department has a policy that applies to every employee, then it needs to be imposed equally against every employee, and it's arbitrary and capricious, again, to deviate from that. As far as I can speak to the personal effect on the employee. Being under investigation is an extremely stressful experience for the employees, and if they know that discipline is coming and they know they have to wait 30 days, 60 days, 120 days, depending on how this is going, and they end up having to wait, 4 to 6 months instead of what the policy says they have to wait, it creates stress, it creates mental anguish, that sort of thing. As far as any sort of, it drags out the process and
But as far as legal prejudice, how does taking more time to investigate something
to make sure they get it right, let's say, let's assume the department saying we want to take more time, so make sure we get it right. How does that legally prejudice the employee?
Again, my opinion on this, and the reason that we filed this appeal, is that the legal prejudice is that it's arbitrary and capricious. It's not just about this policy. It's about the Department of Corrections going to the Personnel Board and saying, these are our policies. We can do what we want. We don't have to follow them.
What about the policy in Rule 601? I think it was. Obviously, it's 601. And I think it was 601. One might be 1.3 that talks about that if a complaint is deemed admitted, that no further investigation may be necessary. Doesn't that give the department discretion to then say, well, just because he's admitted, it doesn't mean that we just have to now act under the 60-day rule. We could require, we think further investigation may be required.
Absolutely, Your Honor, and the policy addresses that as well. And what the policy says is, if the department looks at the admission and says, we don't think that's quite admitted fully, we think more investigation is required, then what they do is initiate an administrative investigation. That triggers another portion of Policy 601 that has 120 days. The 120 days is to complete the investigation.
Right.
And that 120 days, if 120 days is not enough time to complete the investigation, the department also has a policy that says, if you need more time, make a written request stating specificity. It shall state with specificity the reason that you need more time, and the director will consider it. And that, partially that's what happened in this case, because as you know, there were the 3 complaints of misconduct against my client. 2 of them were deemed admitted. The 3rd one initially was deemed admitted, but then as the time began to run, the department said, well, it wasn't quite fully admitted. So what we're going to do is initiate an investigation on that one, and then let's extend the period, the 30 to 60 day
process.
My client didn't have an opportunity because he wasn't told about it. My client didn't know any of this happened until he gets the extension request.
Your client knows the department policy that it needs to be resolved within X number of days. So didn't he have an opportunity to come in and say, look, I want my first 2 violations to be fully adjudicated or to be resolved?
Your Honor, that's not in the record anywhere, but my recollection and understanding is that my client did say that, and the department said, we'll let you know. And, as far as the opportunity...
Is there anything in the record that shows that he objected to the process of essentially consolidating all of the matters?
No, and there's nothing in the record to show, and actually the opposite is true, that my client was never told about the consolidation. The first my client found out about the consolidation of these cases and the fact that they were all being put together and extended was in these extension request documents that were given to us after the department presented their case.
But presumably your client knew, from the record, that your client knew, I know a complaint has been issued on the first 2 charges, and he knew or should have known that he admitted those. Is that correct?
That's correct.
And then the timeline was running, 60 days.
Correct.
And he could have come in and said, hey, 60 days have expired. This is over. And I want a determination that this is over on these 2 charges. And there's nothing, and you're telling me there's nothing in the record that says that?
There's nothing in the record that says that, and there's nothing in policy to allow that. The employee doesn't have the right to control these investigations. The employee doesn't have a right to see the investigations. And in this kind of situation, my client, he knew that he had admitted the allegations.
There's some analogy, for example, in criminal context with Rule 8 violation. We do put some burden on when there's a deadline coming up to at least let people know there's a deadline. I really want you to take this seriously. If you never make any objection and you're just kind of agreeing with the process that's being proposed, it does seem like there is some obligation on the part of the employee to highlight the position that you're currently taking.
Your Honor, I understand that in a criminal context. In this context, there is no such obligation on the employee because there is no policy or rule or anything else that would allow the employee to get that. And I'll tell you, just to follow along what you're saying, one of the first things I did when I filed the appeal was had a subpoena issued that said we want copies of any documents that are purporting to extend or grant an extension of the time deadlines, and I still didn't get them. You know, they still didn't give those to me.
But even in a civil context, if someone says, I'm working under a departmental policy or a contract or something, and says, I know what my rights are, and that if I have someone wants to fire me or someone wants to take action against me, there's a time limit. And the time limit goes, and he doesn't say, wait, you can't do anything. You got to stop now because this is over. But that occurs commonly in the civil context, but why shouldn't it apply here?
Because under Department Order 601, the employee's ability to do that comes when the employee can either grieve the discipline or appeal the discipline. Up until that point, you know, this isn't like civil and criminal where the employee gets to see what's going on and there's transparency about what the allegations are based on.
To the initial point of, is this something that's actionable if the department, this is just their internal policy to make sure these things move along. We don't want to just leave something hanging. But if their policy was 2 days, but that just turned out to not be reasonable, you know, is there a cause of action just because their policy was 2 days, but they didn't comply, they did it within a week?
There is a cause of action because it's arbitrary and capricious. If they want to change their policy, the department has the ability to change their policy. If they decide 2 days isn't enough, they can make a new policy that says, okay, now we're going to, or what they've done, the most recent incarnations of this department order have completely changed this. This isn't the structure anymore. So when the department realized, you know, okay, we don't want to do it this way, clearly they can change their department orders.
But okay. But the problem is if the department does this and the timeline allegedly, let's just say purportedly, all things being equal, that the timeline is run, presumably the employee, your client, can go in to his employer, to the warden, and say, you know, the 6 days have run. You guys have to make a determination.
Your Honor, you're presuming that, but that's not the way this works. That the employee doesn't have the opportunity to go in and say, okay, I want to be disciplined now.
Okay.
The reality of the situation of how this works is the employees have no right to do anything at all until the discipline is imposed, and they have the right to grieve or appeal.
But if the discipline, say on the first two, had been dismissal, it seems like there's an incentive for the employee to want to cooperate and maybe get through all three, as opposed to forcing the department's hand and saying, no, I insist, I want you to follow your policy. I mean, doesn't what the department did in this case, doesn't that benefit the employee by saying, let's look at everything together, as opposed to, if you're going to force our hand, we'll fire you?
Well, Your Honor, it depends on your perspective. If you're coming at this from the perspective of the department doesn't have to follow its policy, then it does benefit the employee to look at them all at once. But if you're coming from the perspective of the department having to actually follow the policy that it's telling its employees that it's going to follow.
I'm coming at it from the perspective of what's fair to the employee, as opposed to necessarily a specific, you know, number of days. And, you know, certainly if there's a due process issue or something where the employee just feels like there's something about the process that's not fair, but to just say, well, this is what's written down as the policy, without showing any kind of prejudice to the employee's position, I have a harder time with that.
Well, Your Honor, again, you know, I know I keep coming back to this, but the prejudice to this employee is that this is a policy that's applicable to the thousands of employees at the Department of Corrections, and he's treated differently. And under the administrative case law, treating an employee differently is an arbitrary and capricious action.
How do we know that they didn't? I mean, each case has to come up on its own merits. How do we know that in some cases the department didn't do the same thing in other cases with other employees?
You know, I wouldn't know unless those employees requested the specific documents that I requested.
So we don't know if they've done that. I mean, you're presuming that they didn't do it to anybody else.
I'm presuming that the department's following the policies that it's telling its employees it's going to follow. My point on this, you know, again, whether it's this policy or any other policy, if the department has a policy and tells employees this is what we're going to do, that's what they have to do.
Counsel, I understand that, and I appreciate that. That's a fair comment. I have another question for you. If I've done the timeline right, I think I have, basically.
Okay.
presumably, when this request for the first request for extension was made, which I think was about August 15th, 2011, give or take a couple of days.
That's correct.
That was within the 60 days on the first two charges. Is that correct?
That's correct.
Okay.
But again, there's no policy that allows that 60-day period to be extended.
I understand your position on that.
Okay.
And then, how do you read that, though? The request, as I read it, seemed to say, okay, we've consolidated the two, we've combined the first two, the key and the inmate, I'll call them the key and inmate charges. And in order to deal with this all at one time, we're going to deal with the Red Book deadline, which I assume meant the investigation on the PAR charge. And so therefore, we would like to extend all of that to keep them all together on the same timeline. Do you see that as a sort of de facto consolidation of all three claims?
I did not, Your Honor, and the reason being that each of these documents in the subject line refers to a request for extension of administrative investigations 2011-0198 and 0952.
On the two 60 days.
On the two 60 days.
But in essence, they're asking for, I mean, the 120 days hadn't even run yet on the third charge.
How do you run the 120 days?
No. The 120 days on the PAR charge hadn't run yet.
Oh, it had not run yet, correct.
On August 15th.
Correct.
So the request seemed to me to be, let's consolidate all three of those and try to get it all done at once.
Okay.
Is that a fair characterization of it?
I believe so, yes.
Okay. I'm not asking you to concede.
No, I
that
understand your question. And Your Honor, my biggest complaint is not with this first request or the second request. I think it's questionable that they were extending these by bootstrapping them to the other charge when the only way you can extend is if there's a pending investigation. You know, Policy 601 doesn't say you can extend the time to consider things. It says you can extend the 120-day investigation period. My biggest complaint is that the third request did not state any reason whatsoever that an extension was needed. And unless there are any other immediate questions, I'm going to reserve the next 3 minutes. Thank you.
Counsel.
Good morning, Your Honors. My name is Lisa Wallen, and I represent the Arizona Department of Corrections in this appeal. And also here today is Jeffrey Bernick, who represents the State Personnel Board. I would like to go straight to the issue that Your Honors were just discussing with Appellant's Counsel with respect to the timelines. And I want to address a couple of the questions that the court posed to Appellant's Counsel. It's the department's position that appellant was not prejudiced by the amount of time that it took to impose the discipline. And it's also the department's position that, in fact, the policy does allow for extensions of the 60-day time frame, and that notwithstanding that, all of the extensions were timely made. In other words, as Judge Kessler pointed out, the first extension was made within the 60 days, and then each subsequent extension was requested before the expiration of the next extension.
Where does it say that you can get an extension on the 60-day where something's deemed admitted?
It does not say that in the policy.
Okay, maybe I misunderstood. I thought
No.
you said that something in there allowed extensions for something that's deemed admitted.
That is how the department interprets their policy.
Okay.
And it makes sense if you think about it, because why would it make sense to allow extensions for a longer time period and yet not allow for extensions for a shorter time period to
Because the
impose
shorter
discipline?
time, presumably, because the shorter time period is deemed admitted. and therefore, why are you extending it?
And the section that talks about it being deemed admitted includes language about unless there's an extension.
Which section of that is that? I didn't catch that one.
It is section 1.1.2.1.4, which is, it's index of,
I'm sorry, 601.
I know it's confusing, 601.1.1.2.1.4.
Okay,
And that's found at index of record 29, page 29.
okay.
That section states that failure to administer discipline or request an extension within the designated time frame will result in a non-sustained finding. And it's our position that the term designated time frame would encompass whatever time frame was designated, whether it's the 120-day time frame or whether it's the 60-day or 30-day time frame.
I did see that one, but I didn't read it the same way as saying dealing with the 60 days.
But in addition to that, as I think it was Judge Catani that pointed out that the three disciplines were consolidated, and it was the department's position, and it was Warden Diaz's testimony at the hearing that the department did consider that to be a consolidation of those three separate disciplines for the employee's benefit, so that it wouldn't result in a progressive discipline type of situation where they were each meted out at different times, but rather consolidating them together so that one disciplinary decision could be made with respect to all three. And so arguably, once the first two disciplines were subsumed and consolidated with the 120-day discipline, they too then were on the 120-day time frame because they were all proceeding lockstep together.
I'm assuming the discipline, say for the first incident or the first charge, the subsequent charges would be relevant, or would they be relevant to the discipline that's imposed for the first two violations? Would the third violation be relevant to the first two violations? That question.
I'm not sure I understand your question. I do believe under the policy that they can stack it, so the first two violations would be relevant to the last one.
But I guess my question is the discipline for a violation completely independent of other conduct that may come up at some point? Is if you only had charges, the first charge relating to the key or the inmate, I mean, could you bring up let's say you had those two charges, could you say the discipline is based not only on that you're kind of a repeat offender, or that there's more than one action that we're concerned about? I guess still a very inarticulate question.
Other than in the terms of progressive discipline, I don't know the answer to that question, Your Honor. I'm sorry.
Let me try to reword it a little bit. Maybe,
Good luck.
I don't know, maybe I can. Let's look at it like criminal proceedings. If you have priors, your range of sentencing is much different. And I guess one of my thoughts, I don't know if this encompasses what Judge Catani was trying to get at, but was that if they had the department had gone forward on, let's say, the key and inmate charge, first two charges, and said, okay, slap on the wrist, suspension without pay for 20 days or something. And then they got to the PAR charges and said, this is more serious. And because you have these prior violations, we're now dismissing you. We're firing you as an employee because of these priors. Could that have been the result, do you know? Versus if it was all considered at once, it would just be they couldn't consider it as far as progressive.
Yes, I do believe that is the case. And in fact, the initial discipline recommended before the cases were consolidated was that appellant would be demoted to a correctional officer too, and he ended up actually getting less discipline than what was originally suggested.
At that point, was the department aware of the third violation?
At the point that that first notice of charges was issued, I believe they became aware of the third charge after that. I believe it was beginning to come to light, but it was also associated with another employee, and they were initially focusing on that other employee, which was appellant's subordinate sergeant. And as they started to investigate that, then they didn't initially realize that appellant was also involved in that. And then once they did was when they saw that there were these three different issues going on at the same time.
Why would the recommendation have been more harsh without knowledge of the third incident?
I'm sorry, Your Honor, I have no idea.
The recommendation is just that of the investigator? Is that the recommendation? I mean,
No, I believe that's the recommendation of the warden, the initial discipline. But it's not, that's not the final disciplinary decision.
I understand that. It's just, okay. And at the end of the day, after the three charges were heard, what was the recommendation of the warden then?
I believe it was what was ultimately.
Imposed?
Yes, imposed.
So it was lesser. Okay.
It's important to remember in this scenario that courts and administrative bodies give deference to an agency's interpretations of its own regulations and statutes. And here, we're not talking about something that's codified and has the effect of law. We're not talking about a regulation or a statute. We're talking about an administrative policy, which in the policy by its own definition refers to itself as a time frame guideline and points out that the purpose of it is merely to track the administrative investigation process. And so back to the earlier point that was raised, besides the fact that the appellant was not prejudiced, these policies do not have the effect of law. So there cannot be any legal prejudice. And, you know, at the end of the day, it, as we just discussed, inured to his benefit, in fact.
Counsel, what do you make of this? I think I raised it with opposing counsel. The 601.01 1.3, which as I read it, or 1.2.3, excuse me. I think 601.01 1.3 says there's no need for an additional investigation if admitted. But then I think under 1.2.3, it says maybe, it seemed to me to give the warden more determination, more discretion about whether an investigation might be needed.
Two responses to that. First, I believe the policy under 1.1.2.3 gives the department discretion where the facts are known and not in dispute. It gives them the discretion to choose the time frame. It doesn't require them to pursue the 30 or 60-day time frame, depending on the nature of the discipline.
That's 601.
That is Index of Record 29 at page 30.
Okay, page 30. And what was the subsection? 601.01 what?
1.1.2.3.
Okay.
I believe that it gives the department discretion to determine the time frame, and then if they determine that time frame, then it shall be completed within that time frame, is what that section states. Now I've forgotten my second point, Your Honor.
Well, let me go back. I'll rephrase. I'll reword the question for you. Maybe that'll refresh you. And this happens all the time, especially when I'm asking questions. 601.01 1.1.3 seemed to say no need for an administrative investigation if it's deemed admitted per 1.2.3, but it seemed to me that gave the warden discretion if an additional investigation was needed.
Thank you, Your Honor. That did help.
Okay.
I do agree that it gives the warden discretion, and also the record supports that. The warden testified during the hearing that although they don't consider it an investigation that's elevated to the administrative investigation unit, they still consider it to be an investigation even though it's proceeded based on a supervisor complaint and not elevated to a red book, as they call it. So to sum up this point, the department's interpretation of its own policy was reasonable. The discipline was timely imposed based on the timeframes in the policy and the extensions requested, the timeliness of the extensions requested, and the Superior Court did not abuse its discretion in finding that the department followed its own policy and in upholding the discipline imposed. I would like to move to the other issue that has to do with the setting of the de novo hearing, but before I do so, I just want to express the department agrees that this court has jurisdiction, and unless the court has some specific questions, I would like to move to the other substantive issue.
Technically, I don't think counsel addressed the first issue. I mean, she didn't really get into it, but if you want to take some time and address it.
Just briefly, Your Honor, and then I'll sit down. The first issue having to do with the de novo hearing, it's our position, first of all, that the department didn't violate 381101, but it doesn't matter because even if they did, the board had discretion under 381101, and the board did find good cause, and the record supports that. Not explicitly, but their order and in the issuance of the order implicitly finds good cause, and they also had discretion under their own statutes and regulations, which, as this court noted in the Blankert case, gives the board broad authority to fashion a remedy with respect to personnel board hearings. And that's all I have, unless there are any questions.
Thank you, counsel.
Thank you for your time.
I want to address briefly the 381101 issue. The personnel board said that its authority to order that de novo hearing was under 381101. If the department did not violate 381101, then the personnel board had absolutely no authority under 381101 to order a de novo hearing. Their only reason, their only stated basis for that de novo hearing was to correct the violation that they found of 381101. The problem, as set forth in the brief, is that the personnel board can only do that, one, if it's harmless, or two, if there's a show, if the violation is harmless, or upon a showing of good cause, then the personnel board can fashion a remedy. The personnel board said this was not harmless. The personnel board said there's good cause because once we order a de novo hearing, it's going to be cured. My problem with that is the personnel board put the cart before the horse. The personnel board said once we do this, there's going to be cause. You know, there's good cause because once we fix it, that's not good cause. There has to be a showing of good cause to trigger the personnel board having that authority to do it. Stepping back to the other issue, I wanted to address again, Judge Kessler, you talked about 1.1.2.3. I read that again, and what it says is the supervisor may initiate disciplinary action if it's admitted, and if they're going to initiate that action, it shall be completed within 30 days. And then the next subsection under that says there's an exception that if it's going to be a more serious discipline, then it's 60 days. The 120 days does not kick in unless or until there's that secondary investigation, the Red Book investigation.
Well, I was actually, Ms. Waller raised that. I was more concerned about the issue that seemed to say no additional investigation may be needed. And I think that's neither 1.3 or 1.2.3. Which seems to me to give the warden discretion to say, you know, even though it's deemed admitted, I may need an additional investigation, and I can see the reason for that. You may have the initial investigation, the supervisor complaint, may have only touched the surface of something, and the employee, not necessarily your employee, but an employee saying, oh boy, I want to get this deemed admitted because I don't want them to see what else I've done.
And I understand that, Your Honor, and I don't disagree that there can be circumstances where something, where, as in this party, one party deemed it admitted and somebody else said, no, I don't really think it was admitted, but the warden had no basis for that. She didn't have any reason for saying, well, this is my issue with it.
Right, but she may still deem it admitted, but say, but an additional investigation may be needed because maybe there's more here than meets the eye.
Correct. I agree that policy would allow that to occur.
Okay. So isn't that what's happening, though? There's additional investigation because the punishment may be more severe if this reflects a pattern of misbehavior. Is that what the investigation is? Could be something different than what's actually been admitted.
No, the additional information is into the allegations of misconduct that were made in the formal complaint to the employee in the original notice of
I
administrative.
think that's any investigation is limited to that.
As you see in this case, Your Honor, if something else comes up during the investigation that's different than what's being investigated, what they do is issue another 601. They open another formal complaint and allow the employee to be aware of what he's being charged with. And if the only other point I had is that the employees of the Department of Corrections are terminated, disciplined all the time for violating policy, regardless of whether there's any actual harm, whether there's any legal prejudice or anything else. The other thing is that the department order, the policy that's in place here, doesn't say we're going to close the case with a non-sustained finding unless there's some sort of legal injustice. It doesn't look at legal injustice. It doesn't look at whether the employee is prejudiced. What the department order says is if it's not done within this time period, it's closed as non-sustained. So at the end of the day, when the employee sees that the 120 days is up, he's not going to walk to the warden and say, discipline me. Come on, I want my discipline. He's going to be waiting for the letter saying, we closed you as non-sustained because we didn't meet our deadline.
But couldn't he wait till the 61st day and come in and say, your time has run?
He could. But there's no policy that allows them to do that, and no policy that forces them to respond to that either.
Thank you, counsel.
Thank you.
We'll take the matter under advisement. We'll issue our decision in due course. Court's adjourned.